Appropriation is the oldest of the four privacy torts, and it basically protects an individual from likeness or an individual's name from commercial exploitation. Basically, appropriation states that it is illegal to use an individual's name or likeness for commercial or trade purposes without consent. Basically, what that means is you can't use somebody's picture, you can't use their name to advertise your product without their permission. And all you would have to do to avoid this problem is to simply get a media release form, have them sign a media release form so you have their permission, so you won't have to go through all this trouble. And if they're a minor, you can have a parent or guardian that can sign the release form for them, so you can use their picture and their product without having any type of trouble. When you think of appropriation, you can kind of think of it as a medical release form when you're on a sports team. Now, if like in middle school, if you played a sport, you would have to have a physical done in order for you to play that sport. And if you don't get that physical done, then you can't be on the team. It's kind of like the same thing. If you don't get their permission or their physical, you can't use them to advertise your product. It's not right. It's not lawful. So the right to privacy is basically to protect an individual from the emotional damage that can occur when a name or likeness is used for a commercial or trade purpose. Now that's mainly used for the common individual. Basically, it's just saying that it wants to protect you from, or it wants to protect the common person from any emotional damage you may suffer when a company uses your name or your picture without your consent. And the right to publicity is an attempt to compensate individuals for the economic harm suffered when their name or picture is used for advertising or trade purposes and they are not compensated for it. Basically what they're saying is this, and the right to publicity is that your picture and your name have an economic value. And so when companies use your name or your picture without your consent, it's kind of akin to theft because it has economic value. And basically that's for well-known persons or celebrities, people that everyone know, like Beyonce or Jay-Z. And when you think of the right to privacy, going back to that, which is protecting the common person, think about the phrase taking your secrets to the grave, because the right to privacy ends when your life ends. So when you die, your right to privacy is ceased, is stopped. And when you think about publicity, the right to publicity, kind of think about it like those lawyer commercials. Like, you know those commercials that come on TV talking about, you know, if you've been injured, call this and this, and call, I don't know, Sanford and Son law firm so we can get you compensated for any injuries that you may suffer. It's kind of like that. Like, the right to publicity is kind of to protect you and compensate you from it for anything that you've suffered if, you know, you're a well-known person or a celebrity.
So we're
recording.
Okay. Hi, my name is Paul Buford. My topics were advertising and trade purposes, news and informational exchange, and the doctrine of incidental use. First off, with advertising and trade purposes, the thing to keep in mind is this is commercial use. Making money off of someone else's likeness, photograph, trademark, what have you. Using someone's name or photograph in an ad, using their likeness to draw attention to someone else's service or a testimonial. Now, the key thing to keep in mind here is consent. So, for instance, if I, being a photographer, did an ad campaign for the Lakers and I used their photos for that ad campaign, we're fine. That's what the contract said. Now, but if I use them for another commercial purpose, like trying to advertise my own services or use them in another promo for someone else, then that's technically a breach of contract, a breach of agreement, and they can sue for appropriation because that's not what they intended. Moving on to news and informational exchange. Long story short, the line between news and entertainment journalism has become blurred due to reality TV, the internet, and just the fact that entertainment news has its own category, along with hard news and other facets of news. So once again, the thing to keep in context here is consent, but also context. For example, there was a movie that came out called The Perfect Storm, and in it they tried to document or make a dramatization of the actual account of the death of two fishermen from like what they call a freak wave, or a freak tidal storm. However, a lot of the events surrounding that were fictionalized in the movie, and the family sued. Rightfully so, because that was messing with the likeness, especially of the dead. It's kind of a red zone to avoid. Lastly, when it comes to incidental use, pretty much if you lend your likeness for a product and the person selling said product packages it with something else, or they display it somewhere else and it serves a different purpose, but it's not beyond the range of what was previously agreed upon. For instance, if they use it, if Amazon were to print my autobiography, my photos on the cover, and they want to use it in a collage with a bunch of other books to show their book selling services, I can't really sue for appropriation because they're just advertising what they have in stock, and also the fact that they are a book selling service. It's not really an appropriation of my likeness because that was my autobiography. It was a book. They are selling books. Everyone's in their lane here. So those are my topics. I'm Paul Buford. That was my time.
Okay.
I had booth rule and consent. Booth rule is using newsworthy material to subsequently advertise the media product. Basically, the court held that such media self-promotion is protected speech that cannot be the subject of misappropriation suits. It was named after the case involving Shirley Booth, who was an actress. She was in Holiday magazine, which had run an authorized photo of her vacationing in Jamaica. A year later, they reprinted the same photo in a full-page ad for the magazine. Another example would be reprinting a picture of Whitney Houston for a pop culture magazine to promote her upcoming documentary of her life. The second term was consent, which is permission for something to happen or agreement to do something. In the book, it says as the Ninth U.S. Circuit Court of Appeals wrote in 2012, consent may be implicit and is to be determined objectively from the person. But in any legal action, the defendant is going to have to prove that he or she had consent. An example of this in the book they gave of a professional tennis player. Her name was Anastasia Meskina, and she gave her consent to release a photo of her to publishers to include in the 2002 sports issue of GQ magazine. However, she felt that the magazine showed her in a light that she did not want to be shown in and appealed to it in the court. The magazine did state that she did give her consent. However, she tried to say that she did not feel that she understood, like she must understood because she did not speak English. However, it was a fail because it doesn't matter whether or not you understood or. However, it was a fail because it doesn't matter whether or not you understood it or not. If you signed the consent form, you signed the period. So those are my two terms.
Consent today may not be valid in the near future. What do I mean by that? Well, a lot of these times, consent is used verbally or physically. So if someone were to ask me, hey, can I borrow your shirt? Or hey, can I use that picture? We shake our head yes, or say sure, why not? But nothing is written down. Now, for example, in the future, let's say that same picture that they gave me authority to use,
I sell it and make profit for it, but nothing was written down, they could take me to court and said I stole their idea, I stole their design, and they can possibly sue me and win. Why? Because it was a verbal response that I received from them and not a written response. So that brings us to the question, when does consent not work? Well, the main 3 reasons where consent won't work is A, if you are under the age of 18. Most states, in order to be considered an adult, you would have to be 18 years and older. So an underage consent might not work. B, if you have a mental illness, so where if you were to give consent, everyone would know you got taken advantage of, that may not be accessible. And C, if you are incarcerated, if you are in prison, and usually the bigger of the crime, the less consent you do have. Which brings us to life after death. Now, life after death is usually used in the sense for celebrities, like well-known celebrities, widely known celebrities, such as Michael Jackson and Elvis. These are people who gave consent while they were alive, so even after they die, there's still a profit being made off of them. So their family members or close friends, ex-wives, etc. won't be able to sue because they already made some type of connection with either the producer or a company, so that way their image is still making profit, so that way that company can still make profit off of them. So even though they're deceased and have passed away, there's still consent life after death.